This is continuing coverage in the trial of Richard Merritt from the Hidden Killers podcast on the True Crime Today network.
All right, so when do you expect your next witness will be here?
She landed at 2:50, so in the next hour.
Okay. All right. So what I may do is let the jury have a little bit of an extended lunch, and we can stay here and sort of discuss the issue, and then I'll hear from her when she actually gets here, if you want me to. Okay?
Okay.
All right. Great, man. And just so that you all know, there was apparently some kind of a leak in the jury room next to us, so we can't go in there. And that's the reason that it's so warm in here. So we may have to eventually move to another courtroom if they have to do work. But we're trying to get them to do the work this afternoon and evening once we're finished.
They were very loud.
Yes, and I've told them they need to be quiet because it is distracting for the jury. All right, ladies and gentlemen, I am going to give you a little bit of a longer lunch today. We're still waiting for our witness to arrive. The next witness, she flew in this morning. And we have a couple of matters that I need to address with the attorneys before we continue on with the testimony. So rather than having you just wait on us, I'm going to go ahead and excuse you for lunch. Ask you to be back at 1 o'clock. You'll meet the deputy again out in front of 7A at the other end of the hallway. And please remember the instruction not to talk about the case or allow anyone to talk to you about the case. All right? See you all at 1 o'clock. Thank you. You all may be seated.
Good.
Yes.
Someone raised a case. The device appears saying low battery.
That's mine.
That's yours? Okay.
That's mine. Wow.
No, that's counting.
What's saying low battery?
The
The controller?
iPad controller.
Okay.
So
We'll call IT.
I assume they can back up.
I hope you weren't asking me to figure out how to fix it. So all I can do is call somebody.
I don't know. I think
It should be hardwired, so I don't know why it would say low battery, but
with this unplugged a little bit.
we'll call IT and let them check it out.
I think it's starting to
Okay.
Well, except for that one thing is powered up. So it's kind of hard time using much of the charge. It's powered on. Right. So you do.
Okay. So let's talk about Miss Richardson. Miss Pott, do you want to start?
Yes. Is this? I just want to make sure that this is not. I don't know if this part of the proceeding is being recorded by media.
Yes, the Rule 22 says that any time that I'm on the bench, it's
Okay.
being recorded.
Your Honor, Ms. Richardson is a PhD candidate. She was actually supposed to do her dissertation last week, but it ended up being rescheduled. I don't know the exact date that she's supposed to present her thesis, but it's supposed to be this spring at some point. She is very concerned that, well, let me explain. She was in Nashville. The defendant introduced himself to her on a dating app. That's how she met him. She met him in person around the beginning of July of 2019, and they started a relationship. She knew him by the name Mick Malvo. She believes that he was from New Orleans. Basically, he duped her the entire relationship that they had through the date of his arrest. She is concerned that she will not be published or invited to participate in any studies if her face is out there. She's not so concerned about her name because it is a somewhat common name, but she just doesn't want anyone to know exactly who she is. And I'd ask not only that her face not be recorded, but that, and Mr. Queen and I have discussed not asking exactly where she works. She's prepared to say that she's a teacher. You've asked what her job is. Not to ask specifically where she lives or her address or her date of birth. So just for her basically ability to make a living and her advanced degree, which she's been working on for quite some time, we are asking that the cameras be turned off, at least visually, while she testifies. Your Honor, if you look at both OCGA 15-1-10.1, that is standards for determining grant of requests for television, videotaping, or motion picture filming of judicial proceedings. Subsection C states that the court may hear from the parties, witnesses, or other interested persons, and from the person or entity requesting coverage during the court's consideration of the factors set forth in this code section. Whether to allow the videotaping is entirely discretionary pursuant to the subsection. And then if you look at Georgia Uniform Superior Court Rule 22, subsection, I believe it's G. That discusses the denial or limitation of recording. And if you look at subsection G1B, the rule states that the consent or objection of the parties, witnesses, or alleged victims whose testimony will be presented in the proceedings basically are a factor to consider in determining whether to deny recording or any type of recording of the proceeding. And it lists out some of the factors to take into consideration. They are whether the proposed recording will promote increased public access to the courts and openness of judicial proceedings. D is the impact upon the integrity and dignity of the court. E is the impact upon the administration of the court. F is the impact upon due process and truth finding. G is whether the proposed recording would contribute to the enhancement or detract from the ends of justice. I don't believe that not recording Ms. Richardson's face would cause any kind of violation of due process, nor do I believe that showing her face would enhance the public access to the courts or openness of the judicial proceedings or the integrity and dignity of the courts. Subsection H says that any special circumstances of the parties, witnesses, alleged victims, or other participants, such as the need to protect children or factors involving the safety of participants in the judicial proceeding, is a factor to consider. Again, this may not be an issue of safety. She is concerned. She managed to not be filmed by the news media, and her personal information did not come out initially when the arrest was made, and she was very grateful of that. She is very concerned about where she lives and the news basically being in her front yard. I states that another factor is any other factors affecting the administration of justice in which the court may determine to be important under the circumstances of the case. And then subsection 2 discusses the limitation of recording. That subsection states, upon his or her own motion or upon the request of a party, witness, or alleged victim, a a judge may allow recording as requested, or may, only after making specific findings on the record based on the factors in the preceding paragraph, impose the least restrictive possible limitations, such as an order that no recording may be made of a particular criminal defendant, civil party, witness, alleged victim, law enforcement officer, or other person, or that such person's identity must be effectively obscured in any image or video recording, or that only an audio recording may be made of such person. And again, I believe that this is the least restrictive manner in which to allow the proceedings to be recorded, because of course everyone will be able to hear what Ms. Richardson has to say in her testimony. And I have no objection to the media seeing the images and exhibits that we plan to tender through her testimony. But I just don't believe that it will enhance justice in any way to allow the cameras to be on.
And I know you've told me about the, excuse me, the meeting and the relationship. So what is the extent of what her testimony is going to be?
Yes, we turn my notes. Okay, she is going, and I wrote this out very specifically because she's very concerned. So I know pretty much exactly what she's going to say. I'm going to ask her name, age, where she lives, and she's going to say that she lives in Nashville in the Music Grove, Vanderbilt neighborhood. She said she met the defendant online and that he introduced himself as Nick. He said that he was from New Orleans, where he owned property, and he had some kind of job in, I believe it was finance, but he quit it and he went up to Nashville to take some time to himself to do some writing. He said that he had published a couple of things, but that he wanted to be a writer. He said that they did meet in person on July 9th of 2019. At the time, the defendant had kind of longer hair, and I've got photos of him at around that time and during the course of their relationship. She will identify the defendant and explain how he has changed his appearance since then. She's going to talk about how he acted during the course of their relationship. You know, they would just go out on dates, started out casually, and it got more serious, you know, after several weeks. In the initial text message from the defendant, he said again that he was from New Orleans, that he had moved in early February from New Orleans. He had written he'd written up to 188 pages of his first novel, and then moved to Nashville after saving up money from being a marketing executive. And he just wanted to be true to himself and write. She said that she believed he had been crashing at a cousin's house. He told her that he was living with a cousin, that she never went to his house. He said that he had a father who had been in the military and died 15 years before, and that he had a complicated relationship with his mother, and that she had died a few years before of cancer. He said that, I honestly cannot recall it. He said that he had been married before to her, but he did say that he did not have kids, but he had a niece that he characterized as being disabled. He never said he said he went to school at LSU, and in fact he took Kelly to an LSU football game against Vanderbilt because they lived in the area, and he seemed very disinterested. He was working at a bar called Betty's Grill. He would pay for items in cash and maybe a prepaid credit card. She did see his identification. He had a temporary license, which we do plan on introducing into evidence through the U.S. Marshal. He said he was having problems getting a permanent one. He was driving Shirley Merritt's Lexus, and he was very proud of that Lexus because, as she has described, it seemed like it was kind of the nice thing that he deserved in his life. He would stay at her home often. This caused some issues because, again, she was studying and teaching and working, and he had been there. He was there quite a bit. On August 31st, 2019, Georgia played Vanderbilt at Vanderbilt. She said that he was he seemed odd that weekend, and in retrospect, she believes that he was kind of staying in and very cautious about potentially seeing folks from UGA because he had been very involved in the UGA community and was quite a UGA fan. She did not learn that he was wanted for murder until after he was caught. She learned it from a local news website. I do not intend to ask her whether she assisted the U.S. Marshal or Nashville PD. I don't believe that that's relevant to the case, and I ask that that should not be asked that question. Additionally, Kelly had a knife in her house. I hadn't planned on asking her this, but she did tell me kind of a strange story that he had kind of moved the knife. I think it was above the refrigerator, or he moved it to above the refrigerator and put it in the drawer or something. She has received postcards from him from the jail. And I can show the court the exhibits that I plan to admit as well.
Judge, as to the issue, showing her face, not showing her face, I told Mr. Peters multiple times, she's asking, the defense has no position, that's the court's discretion. So we're in no position as to her face. Now, Ms. Pot did bring up one issue related to, the presentation of evidence.
So just so that we're clear, before we move on to specific parts of the evidence, you're indicating that you don't have an objection to her face not being shown.
I don't have an objection to her face being shown, not shown. We're in no position on that matter.
Okay.
Judge, we do have concerns regarding text messages. Basically, I believe that there is authentication and there is hearsay issue as to those text messages, which Ms. Pot just referenced. That's a whole different matter.
Okay. Well, I think we do need to make a record when she gets here. I, at this point, would be inclined to just instruct the media not to show her face, but her testimony would still be available to be recorded and disseminated. So, but I do think we need to make a record. The cases and the statute talks about there having to be some established reason for the court to deviate from the provisions of the Rule 22. So we can address that more when she gets here.
And just for the record, I am making this motion on her behalf, but I also can provide, if the court deems it appropriate, I can provide copies of the exhibits to the media if that would help alleviate any kind of issues.
All right. Why don't we talk about the text messages since we have some time?
May I provide a copy to the clerk? These are marked, and I intended to make them States Exhibit 73.
Okay, so Mr. Queen, tell me what your issue is with this exhibit.
Judge, we have not received, we have the text messages. We have not received a certified or a representative representation as to the authenticity of the record.
The authenticity of these screenshots?
Correct.
So,
And we don't have phone calls, we don't have anywhere. That's how we will call, I guess, yeah.
so why can't she just identify the screenshots?
Well, the screenshots are also the hearsay within the screenshots.
Okay, what's the hearsay?
Hearsay is allegedly from this person, Mick, and we have no way of authenticating that Mick, in this case, who's supposed to be sending messages, is the defendant.
But if she can testify that that's how she was introduced to him and that's the name that he provided, that's who she communicated with, and that's who she knew as Mick, and Mick is this person in her phone, what other authentication is required?
Well, I guess the question is, like you said, Judge, we had to have a bunch of foundation.
Right.
And like presuming that all the foundation issues are taken care of, then I think our issues will be alleviated.
Okay.
But
Have you had an opportunity to speak to her?
No.
Have you tried to?
We reached out to her, actually. Yeah, we did speak to her. Way back when. We did speak to her way back when.
So you did speak to her?
Yes, we spoke to her.
Did you-
way years ago.
Talk to her about these
We
messages?
have not.
Okay. Do you need some time to speak to her about the messages?
So he gave us probably like 3 minutes to talk to her, just to ask her about the messages. And then, like I said, if the state can lay the proper foundation, all things will be an issue.
Okay. All right. Are there any other issues we need to address?
No, Judge.
Okay. All right. So, I'm going to give that back to Scott. All right. Okay. Anything else from the state?
No.
All right. Well, we'll be in recess until 1 o'clock. Thank you.
You're listening to the trial of Richard Merritt from the Hidden Killers podcast on the True Crime Today network. Press subscribe now and get ad-free episodes by upgrading to our premium experience through Apple Podcasts. More next.